Logo fades into view. New York Association on Independent Living. Thank you to our 2022 webinar series sponsor, Waymo. Good morning, everyone, and welcome to our May webinar in NYL's 2022 webinar series. The webinar series is sponsored by Waymo. We do have closed captioning available for today's webinar. You may have to enable that in Zoom. We'll be using the Q&A function for today's question and answer. And we're so pleased to welcome John Herrion from Division of Human Rights. John's going to be talking about human rights law and as it relates to public accommodations and hopefully increasing access in our communities and how you can get involved and spread the word. So without further ado, I'm pleased to welcome John Herrion.
Hi, thanks so much, everybody. My name is John Herrion. I'm the Director of Disability Rights for the New York State Division of Human Rights. Really appreciate the opportunity to be with you all today. I've been with the agency a little over 14 years now. And prior to that, I worked with the Eastern Paralyzed Veterans Association and United Spinal Association doing civil rights work for people with disabilities. I actually got my start at an independent living center back when I was in law school in the early 90s. And I interned at the Rockland County Independent Living Center back right around when the ADA was passed. So always very much appreciated the work that that independent living centers do on behalf of people with disabilities, and just very much appreciate the opportunity to be with you all this morning. So I'm going to share my my screen, which is a PowerPoint presentation. Oh. And so, yeah, what we'll be speaking about today is the rights of people with disabilities, but with a focus on places of public accommodation, what those places' obligations are under the state human rights law to ensure that people with disabilities have access to goods and services. Just clearing this here. We're going to cover the types of conditions and impairments that are covered as disabilities under the state human rights law. Talk a little bit about the distinction between the state human rights law coverages and the Americans with Disabilities Act and protections for people with disabilities. We'll talk about what a place of public accommodation is under the state human rights law, what types of discrimination are prohibited. We have a unit here at our agency, the Division Initiated Investigation Unit. I'm going to talk a little bit about their work and some of the campaigns that have been undertaken by that unit. And also, lastly, just how our agency enforces the state human rights law, how complaints can be filed, and how that process unfolds. I'm happy to take questions as I go along. I have my PowerPoint up, so I don't know that I'll be seeing the questions in the Q&A unless it pops up. But any which way, we will get to your questions before the end of the program, and you'll also have my my contact information in case you want to connect with me afterwards. If you have any questions, I'm happy to help out and be a resource for you all. So we'll start here with the definition of disability. So this slide comes from the statutory definition of disability, and it speaks to physical, mental, or medical impairments resulting from any number of conditions which prevent the exercise of a normal bodily function, etc. A record of an impairment is also covered. This can be somewhat relevant now to the the pandemic we're in. Somebody could have been diagnosed with COVID earlier on, during the course of the pandemic, and maybe a disclosure is made somewhere down the road, or he or she is applying for a job and there's some type of an impermissible or unlawful inquiry that occurs during the job interview or on the job application. And even though the individual no longer is being impaired or is experiencing the symptoms of COVID-19, just having that record of at one point in time being diagnosed with it or being infected with it and then being discriminated against based upon that record of an impairment, even though now the person is presenting themselves as perfectly healthy. You could have an uneducated individual not wanting to employ or hire such an individual. And even though that person may no longer be presently impaired, having that record of the impairment is something that would cover them as well. Also, condition regarded by others. You could have a place of public accommodation make some type of stereotype, make some type of an assumption that somebody has a disability and deny them services because of that assumption or because of that perception. And if that individual is denied services because of that and files a complaint, the owner of that public accommodation then cannot say, oh, you're not covered by the law, you're not disabled. If you were regarded as being disabled and an adverse action was taken against you based upon that perception, you're also covered under the state human rights law. And all of these also mirror the Americans with Disabilities Act, with one important distinction that I'll cover here now. So when we're talking about the Americans with Disabilities Act, the definition of disability requires a substantial limitation of a major life activity. When we go back to the slide here on our statewide definition of disability, you don't see that phrasing. There's no qualifier there that the impairment be substantial. It's not necessary to affect a major life activity. So when courts have looked at cases, when complaints have been filed under both the state human rights law and the ADA, there's a select number of cases where the definition of disability or the person's impairment under the ADA was not considered to be substantial or did not impact a major life activity. And the federal case, the federal cause of action brought under the ADA was dismissed, but the state action was allowed to proceed because of the definition of disability being more broadly construed, being more generous. So what I like to say, the takeaway there is we don't get so hung up on how disabled you are under the state human rights law, but we're more so focused on whether or not discrimination took place. I think that's where the focus should really be. When we're talking about places of public accommodation, we cover most businesses and places that are open to the public. There's very few exceptions. There's a listing here. This is not an exhaustive list. This is just a list that comes from the statute. So you can see a wide variety of facilities that are open to the public are covered. Hotels, motels, restaurants, retail, healthcare providers. We get a number of complaints here. Sometimes people confuse medical malpractice with discrimination. So whether or not you have a disability and a doctor treats you in a way that is malpractice, that would be a separate and distinct cause of action, not something the Division of Human Rights would cover. But if a doctor were, let's say, to refuse to provide a patient who's deaf with a sign language interpreter, or refuse to provide some type of reasonable accommodation to communicate with a person with a disability, that would be something we would take a look at and investigate and prosecute. Movie theaters, amusement parks, state and local government entities are also covered under the state human rights law as places of public accommodation. So if you're being denied services because of your disability by a state or local government entity, state or local government agency, we do have jurisdiction over those entities under the state human rights law. I have websites bold-faced here on the slide because that's been a little bit of an area that's been developing, whether or not a website is a place of public accommodation. The Division of Human Rights takes the position that websites are places of public accommodation. And indeed, the U.S. Department of Justice just recently issued guidance. And in that guidance, the Department of Justice clearly took the position that the ADA's requirements apply to all services, programs, or activities of state and local governments, including those offered on the web. And that language comes directly from the guidance. And here we're talking about, Title II entities, right? Services, programs, or activities of state and local governments. The same also applies to Title III entities. so that the ADA's requirements apply to all goods, services, privileges, or activities offered by public accommodations, including those offered on the web. So I think that's, we take that as being very helpful. Some of the case law previously indicated that you had to have a brick and mortar store in order to be considered a place of public accommodation. And, that it used to exclude places like Amazon and other, large online retailers. But I think now with the guidance that's been issued and some of the case law that's been established, we can cover websites as places of public accommodation, which means that they too need to be accessible for people with disabilities. For those of you who are interested in the guidance, and I'm happy to have this PowerPoint be shared with folks who need or would like to have it shared or have it as a resource. Once we're through with today, you can certainly, certainly have it, not a problem. And here is the website where the guidance can be found. I think the challenge remains, though, is what's standard, right? So while Department of Justice guidance stated clearly that websites are considered to be parts of places of public accommodation, I think there's still a challenge in that there's no real, defined standard. That if you meet this standard, if your website meets this technical standard, it meets the requirements under the law. But I also think it gives some latitude that's also helpful. Once you have a standard, a place may meet the standard, but still in some way, shape, or form end up being inaccessible to somebody with, maybe some type of distinct disability or some type of distinct need related to their disability. And, for me, I kind of, and for our agency, I like the latitude a little bit and the elasticity that's provided by the law to say that, when we get a complaint here and an individual says, this is the reason why this website is not accessible, I've asked for the owner of the place of public accommodation to, to modify the site to make it accessible to me. That request was refused. We can then look to see, okay, what is the distinct need this particular complainant has, and why isn't that need being met in order for us to remedy it? So I think that's actually helpful in certain ways, while it remains challenging in others. So what are the obligations? So places of public accommodations are obligated to ensure access to goods, services, and facilities by making reasonable accommodations for persons with disabilities. And we'll get into some of the specifics. So when we're talking about modifying a rule or a practice or a procedure, we can be talking about a wide variety of things. These are just two examples that I'm sharing here, but there's many, many more. And I'm sure that you folks that work at the independent living centers, work on a wide variety of ways that places of public accommodation can modify the way they provide goods or services to people with disabilities. Staff training is a big one for us. Oftentimes we'll get complaints here at the agency, and when the complaint gets filed, the attorneys or the legal office that represents the place of public accommodation will invariably say, boy, we just need to make sure our staff gets trained on these things so that we don't have this situation happen again. Example, again, I'll pick on the healthcare providers. We'll have a complaint filed against a doctor's office, and somebody who needed a sign language interpreter contacts the doctor's office, and the office assistant answers the phone. He's the one responsible for making all the appointments, and makes a decision, a uninformed, uneducated decision, to say, we don't, oh, you can bring a sign language interpreter, but we don't provide them, or we sometimes get that, well, do you have somebody in your family who can sign for you so that we can communicate? And, those aren't the answers that provide effective communication for people with disabilities. The place of public accommodation has to provide the sign language interpreter and make sure that's available to the individual with a disability. And again, oftentimes it's a matter of training, ensuring that staff who are kind of the frontline individuals who are picking up the telephones, or on the chat, now it's chat, right? You get somebody right up on the screen to chat with. Those individuals who are public facing, doing customer service work need to be trained and educated on what their obligations are, because they can expose their agencies or the places that they work for to liability, under the law. And so training is a big component to ensure that staff are aware of what types of accommodations people with disabilities, are lawfully entitled to access goods or services. And this now is a big, much larger example after the pandemic, is providing curbside service, providing home delivery of goods or services. Most places now provide this as a way of their staying in business. Others don't. But if you have a need for home delivery or provision of curbside service because of a disability, you can certainly request that, and that can be another example of a modification of a policy or practice to ensure that goods and services are available to people with disabilities. I'm going to talk a little bit about guide, hearing, and service dogs, as well as service animals in places of public accommodation. There's sometimes some confusion here in this area of the law. Invariably, the press loves to get involved with some of these cases. I think it was the service peacock on an airplane not too long ago. I think the New York Post really loves to run with those stories, and it becomes a problem, because what happens is it kind of uses a very broad brush to paint over people with disabilities that really need a service dog or a guide dog or some type of service animal because of their disability, versus people who may otherwise be gaming the system, and kind of using those outrageous scenarios to say, oh, this is what people with disabilities are trying to pull, is not fair. In many ways is not really lawful. So let's talk a little bit about the obligations under the state human rights law and the ADA when we're talking about service animals in places of public accommodation. So we have a provision in our law, in the New York State Human Rights Law, section 29614, that provides some pretty strict protections for people when they're using guide, hearing, or service dogs, and the word is dog. And the section there says anybody who's accompanied, an individual with a disability who's accompanied by a professionally trained, and this is the state human rights law. I know in the Americans with Disabilities Act, the phrasing there is individually trained. And I'll get to, you don't have to have professional training to meet our requirements under the state human rights law to be able to go in to a place that's open to the public with your service dog. It does not have to be professionally trained. Let me emphasize that. But if the dog is professionally trained, as most guide dogs are, as most hearing dogs are, as some service dogs are, if there is a professional training component there, under 29614 of the state human rights law, that dog goes where the person goes. There's no reasonable accommodation analysis. There's no undue hardship analysis. So when we get these cases, our investigators are first asking, has the dog been professionally trained? And if that is the case, the dog is going where the person goes. Now, this usually raises the question, if I'm doing this presentation to business owners, invariably they'll ask, can we ask for papers? Can we ask for a certificate? Can we ask for a card or some type of vest or some type of proof that the dog has been professionally trained? And the answer under the Americans with Disabilities Act is no. The only questions you can ask are, is it a service animal? And what type of service does it provide? So asking for, has the dog been professionally trained? I want papers, I want the certificate. If the business owner then says, I'm not going to allow you in without proof, they're violating both the state human rights law and the Americans with Disabilities Act. So although we have under the state human rights law this extra layer of protection for people who use professionally trained guide, hearing, and service dogs, It does not then open the door for a business owner to ask for some type of certification that the dog has been professionally trained. So this is the language that comes out of 29614. It says it's an unlawful discriminatory practice for any covered person to deny access or otherwise discriminate against an individual who's blind or hearing impaired or somebody with another disability, because that person is accompanied by a dog that has been trained to work or perform specific tasks for the benefit of such person by a professional guide, hearing, or service dog training center, or a professional guide, hearing dog, or service dog trainer. And that's the language from the statute. So we have dog trainers that are covered. So if somebody is, dogs have to be trained, right, to be helpful and to be of service to people with disabilities, but also not to be distracted. If a dog needs to be in a, retail setting, restaurant setting, some other setting where there's a lot of distractions, right? The dog is supposed to be trained to ignore those distractions and to, assist the person with a disability to either navigate, getting in and out, remaining safe, or to whatever the service is, the dog that's being trained to do, the trainer is allowed to say, hey, I'm training this dog today, and I'd like to have the dog come in, with this individual. A owner of a place of public accommodation cannot say, no, I don't want you bringing your dog in here for training purposes. They are explicitly covered under the state human rights law as well when they're doing their dog training. So when we're doing an investigation here, when we get these cases here at the Division of Human Rights, my investigators always enjoy this slide because the first question is a pretty easy one, right? Is it a dog? If it is a dog, yes. Okay. Has the dog been professionally trained? Yes. Okay. Here we're talking about what we call the 29614 dog. That dog goes where the person goes. Again, no reasonable accommodation. There's no like unless after the statute, right? In this section of this long section here, right? You don't see the word unless anywhere, unless it creates an undue hardship or unless it's unreasonable. That dog goes where the person goes. But again, it's reserved for dogs and it's reserved for professionally trained dog. Does that mean that only dogs are allowed into as service animals? No, it does not. It means there's one other type of animal that is allowable, and that's a miniature horse per the Americans with Disabilities Act. Does the dog have to be professionally trained? No. If the dog has not been professionally trained, we then still can consider it a service animal. But we do undertake a reasonable accommodation analysis there. Okay, so that's how that works out. So what types of services can dogs be trained to do? We did a program up in Rochester a couple of years ago where we had a veteran who was the keynote speaker, and the veteran had PTSD, and he gave a really interesting explanation of what his dog did for him. So he said the dog had been trained to do two things. One was to be aware of the manifestation of his PTSD symptoms. So this particular individual said like the volume of his voice would increase if he was agitated by something. He would get very rigid. And the dog was aware of these changes in this person, in his owner's behavior and the manifestation of these symptoms. The dog was then trained, once it became aware of these symptoms being manifested, the dog was then trained to do figure eights in between the veteran's legs, and that got this person's focus off of whatever the triggering event was for his PTSD, and looked at the dog and calmed down, took a few breaths, and it diminished what could then turn into a very bad situation for this gentleman had he decompensated because of his PTSD. And I thought that was a really good example, because sometimes there's some confusion around whether or not it's an emotional support animal, which, as I'm going to get to in a bit, are not covered as service animals under both the ADA and the state human rights law, or is this an animal that's been trained to provide some type of a service? So calming a person down with PTSD by engaging in an activity. And again, these are 29614 dogs. So if a 29614 dog has been professionally trained, but it's not necessary. I don't recall if the veteran trained his dog or if the dog had been trained professionally. But either way the dog gets in, I don't want any confusion here to reign. I don't want people to come away and say, from today's training and say, the dog has to be professionally trained in order to get in. It's not the case. There's just an extra layer of protection for dogs that are professionally trained. Dogs can be trained, to alert somebody to take medications. I know when we've worked with groups of people that agencies that are dedicated to people living with autism, they've said that dogs can be trained to prevent the bolting, that bolting manifestation that sometimes people who are living with autism do, can also mitigate or eliminate some of the impairing effects of autism. So again, what we're really looking for here when we're talking about a service dog is, has it been trained? Now, it could be trained by it could be trained by the person with a disability. I mean, that meets the ADA requirements and our requirements. If the dog has been individually trained, it could be a service animal, and that's fine. But that training component, I think, is what distinguishes a service animal from an emotional support animal, right? So when we're talking about housing, and again, today's focus is on public accommodations. So again, don't come away confused with this. But in housing, emotional support animals are allowed as a reasonable accommodation for somebody with a disability. Somebody who has depression is seeing a medical care professional for depression, and that medical care professional says, I think you would do well to take care of an animal that might improve improve the quality of your life and diminish the effects of depression on you. In housing, emotional support animals are allowed. There's no training component there. It's the relationship the person has with the animal that improves the quality of their life. Service animal under the ADA and under the state human rights law, which applies to places of public accommodation, not where I live, but some place that's open to the public, where other members of the public are, their emotional support animals are out, but service animals are in. And when our investigators get these cases, what they're looking for is there a training component so that we can establish that it is a service animal and not an emotional support animal. So here again, we're emphasizing that emotional support and companion dogs are not service dogs in public accommodation cases. And the state human rights law adopted the ADA requirements, which the phrasing there is service animal, and service animals are dogs or miniature horses, and does not include, again, emotional support or companion dogs. Miniature horses are included because they live a lot longer than dogs. This was explained to me at one point in time when I was curious about that. They have a longer lifespan, and that training component doesn't come up as quickly as it would for somebody who relies on a dog. I can't say that I've seen the miniature horse in action, the service, but many times, I've been told miniature horses are oftentimes even smaller than some of the larger service dogs. So point of interest there. When we're talking about what rights does an individual have with the service animal, they can take them into all areas that are normally open to the public. They're not to be isolated, segregated, or otherwise less favorably treated. A lot of times we'll have restaurants say, oh, we don't want the dog in because we serve food. And there's a health code issue here, and we can't allow the dog in. Or what if somebody's afraid? Or what if somebody's allergic? None of those are valid reasons for denying access or refusing service to somebody who shows up with their service animal. Now, if the dog goes into the restaurant and starts, jumping up on the salad bar and is making a mess of things, then we can have the dog being put out of the establishment. But making an assumption that just having the dog there is going to create a problem is not enough to say, to allow a owner of a place of public accommodation to deny or limit where that service animal is going to go within the facility. The service animal does have to be under the control of the person with a disability. That often means a harness or a leash or other tether. If there's a case where the disability does not permit the animal to be harnessed or leashed or tethered, because that would interfere with the service animal's safe and effective performance of their work, the service animal must otherwise be at the handler's control. And that's something our investigators will be looking to work through if that issue presents itself. And again, we covered this. If the animal is out of control and there's no effective action taken to control it, or there's a safety issue that happens, again, we're going to assume it's going to happen because the dog is there, but that the dog is being violent or creating other problems, the dog can be placed out, of the facility. The care and control of the animal, and again, these come from the regs. This is not made up, policy or protocol from the Division of Human Rights. This is in the regs, that the control of the animal is the responsibility of the handler. And the public accommodation is not to be responsible for any care or supervision of the service animal. We talked about inquiries. Public accommodations can only ask, is it a service animal, and what work or task is the animal providing? There's no requirement for, or there's no allowance for a public accommodation to require documentation or proof that the animal has been certified, trained, or licensed as a service animal. Again, our investigators may ask that question if there's professional training and proof thereof, but that's once a complaint has been filed with us in order for our agency to determine whether or not it's a 29614 dog or not. And again, a public accommodation cannot make inquiries about service. If it's somebody who's clearly blind, who uses a guide dog, there shouldn't be a lot or anything really in the way of inquiry there. And fees cannot be charged. Okay, you can bring your service animal in, but we want to charge you a fee for the presence of that animal. Those types of things are unlawful. So that wraps up guide hearings and service dogs. Wanted to talk briefly about auxiliary aids and services. You can't, you have to place a public accommodation has to make sure that people with disabilities aren't excluded because an auxiliary aid or service is not being provided. That gets balanced against whether or not the providing that aid or service would fundamentally alter the nature of the public accommodation or result in an undue burden. And those are pretty high thresholds to meet. So what are we talking about when we're talking about auxiliary aids and services? We're talking about sign language interpreters, providing materials in alternative format, or acquiring or modifying equipment or devices. There's and you folks know better than anybody else probably, there's a whole industry of assistive technology that's out there that assists people with disabilities to communicate and access goods and services. These are just a couple of examples here. Architectural barrier removal is another element of ensuring people with disabilities have access to goods and services at places of public accommodation. So here we're talking about removing architectural barriers where it is readily achievable to do so in order to make premises accessible to people with disabilities. When we're talking about readily achievable, the standard there is easily accomplishable and able to be carried out with much difficulty or expense. So there the standard isn't quite so high, right? The wording in the statute is easily accomplishable, able to carry it out without much difficulty or expense. When we talked about auxiliary aids and services, we talked about undue burden. That's the last phrasing there in that section of the statute, that refusing to provide an auxiliary aid or service unless it creates an undue burden. Undue burden is significant difficulty or expense. So there's a distinction there when something's being asked for in the way of an auxiliary aid or service. Place of public accommodation has to provide that unless it results in a significant difficulty or expense. We're talking about architectural barrier removal. It's a much lower standard or a lower threshold. If it's not easily accomplishable or not being able to be carried out without much difficulty or expense, place of public accommodation may not be required to do it. Now, we take these on a case-by-case basis. So what's readily achievable for one owner of a public accommodation may not be for another. So as an example, you may have some, larger, more successful franchise, let's say like Starbucks or Walmart or Target. What's readily achievable for them is much different than maybe somebody's local cafe who's operating online, maybe a line of credit, or is barely making ends meet. And we're not in the business of bankrupting places of public accommodation to make them accessible, but we'll look for alternative means. So the first part of the investigation is, okay, why is this not readily achievable? I don't think Walmart or Starbucks is going to be able to get off the hook by saying it's too expensive, right? Their threshold, because of their resources, is going to be much higher than that local cafe. So that's what we're looking at there. And if indeed it is a more localized cafe, or a localized business that doesn't just have the resources to spend, which can be thousands and thousands of dollars for a ramp, or, when you're talking about permitting and everything else that goes into it, it can be expensive. Maybe doing something alternatively, temporary ramp. I think I was talking to Alex before our presentation. We came across, and we'll have to see what the resource is, but it was like a hardened, rubberized ramp that could actually be unrolled and rolled back up, so that if somebody needed to get in, there was a step there. It could easily be put in place, rather than those heavy, metallic type portable ramps that can be sometimes difficult to put in or out. But again, we're looking at alternative ways to provide accessibility. If putting a permanent ramp is always the most desired, remedy, because once it's there, it's there. You don't have to worry about somebody taking it in and putting it out. But if there indeed is a cost, if it indeed is not readily achievable, having an alternative available is something we also look to make sure can be done. So, some pretty straightforward examples: putting in a ramp, widening a doorway or checkout aisle, making curb cuts are all examples of architectural barrier removal. Talked a little bit about this earlier, as we were preparing this presentation, and shared, that we had done a number of one-step campaigns, around the state of New York. And I'll talk a little bit about our division-initiated investigations unit. So that unit is dedicated to doing pattern and practice of discrimination, impact work around patterns and practice of discrimination. So what we had done was we just chose a couple of different locations around the state, some of which had local independent living centers. And we just kind of did a Main Street investigation. We walked up and down, the Main Street areas where different businesses were congregated. And we took a look at the low-hanging fruit. Which businesses have maybe one short step to get into, where there could be an easy, readily achievable fix to make it accessible. Sometimes we found that the store did have a portable ramp, but no signage indicating that it was available. And that didn't help somebody who may otherwise go by in a wheelchair and figure, well, I can't get in and out of there. That was an easy fix. Easy fixes also included, those short one steps that could be made readily accessible. And we would reach out. We worked with, I think we had over 100 different businesses around the state, which actually did make their facilities accessible by eliminating that one step, by installing either a temporary ramp or permanent ramp. And again, we were looking for the low-hanging fruit, so. But that was something Alex and I had talked about as maybe being something, we could partner with other ILCs on. We don't have the resources here at the agency to walk up and down every Main Street in the state of New York, but maybe your local ILC has the staff to do that. And you folks probably have better working relationships with the local, or not, with the local buildings departments or the local chambers of commerce. Quite honestly, the businesses that got it were the ones that treated it as a customer service issue, right? Let's get more customers into the business to spend their money. So this may be kind of a project or initiative we can take from here, work with different staff from different centers, talk about how we did it, what worked, what didn't work. and then what role, our agency would play, if you indeed, identified a business that was, had maybe one step, could be made accessible, was a successful business. It would, the question of readily achievable really wasn't going to be a problem, but they've still refused to provide the accommodation. What role would our agency then play by way of enforcement? And of course, we talked about this too, the service and delivery of goods in the time of COVID-19 has meant that businesses have to adapt and have to accommodate so that people, can get curbside service or delivery at home. And that can help people with disabilities fundamentally. And then, the filing of the complaint if it gets refused ultimately. So filing a complaint, how do we do it, right? We've talked about a lot of obligations that different, business owners have to make their facilities accessible. You have somebody come in and say, I asked, there's a new restaurant in my neighborhood and I wanted to go there with my family, but there's a step out front. Or, I've been going to my dentist for years now, and the dentist insists that I bring my daughter with me, to sign so that he doesn't have to provide a sign language interpreter. What do we do about those things? Well, you can file a complaint with our agency to investigate these cases. There's no filing fee. You don't need to have a lawyer. We have regional offices located around the state. Their contact information is on the website there on this slide. We have complaint forms available on our website. You can download the complaint forms. We really try to be user-friendly in this regard. If somebody needs a sign language interpreter to communicate with one of our investigators, if somebody needs a complaint form in alternative format, including Braille, we have Braille complaints available, including in Spanish. We're a user-friendly alternative to the state court system. That's why the Division of Human Rights was created in New York State. And as such, we make it easy for people to file complaints. You can send it in electronically. It's very easy to file a complaint with our agency. You have up to 1 year to file your complaint with our agency. If you've missed that 1 year window, you can go directly to state court, and you have up to 3 years to file. You cannot do both. You have to choose one or other. Our complaint forms are available. Here's one of the more important slides. Our website is www.dhr.ny.gov/complaint. What happens when a complaint gets filed? Well, once it gets filed, it gets assigned to an investigator. The investigator is going to gather information, speak to the complainant. That complaint will get served on the respondent. I sometimes get asked, can I file this anonymously? And the answer is no. You have to put your name on the complaint. Don't forget about our division initiated investigations unit, but they're more focused on pattern and practice work of discrimination. So if this is a very individualized situation, they're probably not going to be available to assist with that. And the person will have to put their name on the complaint. The complaint gets served on the respondent, and we require that respondent to serve us with a written answer. The complainant will see that written answer and have a chance to rebut it. So complainant gets 2 bites at the apple to rebut what the respondent's position is. And following that, the investigator is then tasked with determining whether or not there's probable cause to credit the allegations in the complaint. Probable cause doesn't mean you've won. It does mean that there's enough there to credit the allegations in the complaint, to have an attorney from our prosecutions unit assigned to the complaint and prosecute the case before an administrative law judge, where there would be a public hearing. At the public hearing, testimony is taken, under oath. There's witnesses, there's evidence, a record is made. All complainants that are before our agency can be represented by our prosecutions unit. Some complainants do come with private counsel, and that's fine. The administrative law judge, after the hearing, then is required to submit a recommended order to the commissioner, and the commissioner is the final arbiter of the decision, makes the final order as to whether or not discrimination took place. And then all of the remedies that would be available in state or federal court are also available at our disposal, and we can enforce those remedies. We can order to cease the discrimination. For employment cases, it could mean reinstatement to a job. Housing cases, it could mean providing the housing accommodation. What we've talked about today, making sure access to goods and services made available. If there's a reasonable accommodation or modification that was requested, to ensure that that was provided. Requirement for training, civil fines and penalties are also available. Before I get to my contact info, I should have also included, and this is an important distinction between the state human rights law and the Americans with Disabilities Act, is compensatory damages are available. So if a place of public accommodation has denied somebody with a disability access to services, unlike the Americans with Disabilities Act, and I'll have to create a slide, I should have had a slide on this, under the state human rights law, compensatory damages are available. So a complainant who's been harmed by the discrimination can be compensated for that harm that they experienced. So if you want to connect with our agency, if you have any questions or requests, our phone number is there, 1-888-392-3644. We have an email address, which is info@dhr.ny.gov. My contact information is there. John, John, Herrion, HERRION, @dhr.ny.gov. And my number is 718-741-8332. And this is just a little fancy. This is the slide that I did, and this is the slide that External Relations did. So it's much fancier and better looking. But our phone number is there, our email is there, our website, www.dhr.ny.gov. And we also have a social media presence on Twitter and Facebook, etc. I know we have some questions in the Q&A, so I'm going to turn over to that.
Yeah, John, I can help you go through some of the
Yeah,
questions.
that'd be great. Why don't you
I'll
take
read
me
them
through it?
So I think I'm just going to start with some of the ones that are written out here, just because it's going to be quick just to go through a few. So Jan Lynch is asking, what about sidewalks and crosswalks?
So sidewalks and crosswalks that are owned either like by local municipalities, it's the town, it's the state, it's the city, it's the county that own the sidewalk, and like a curb cut is being asked to be put in, both under Title II of the Americans with Disabilities Act and under the provisions in the state human rights law that cover places of public accommodation. There would be a requirement for the owner, the public entity that owns that sidewalk, to make the curb cut or do whatever would need to be done to make it accessible for somebody with a disability. What we want to be able to demonstrate in all of these categories is that a request has been made. The language in the statute says it's unlawful to refuse. So you always want to demonstrate, that we reached out to the business owner, we reached out to the municipality, and either we were ignored or we were denied, and that's when we can get involved.
There's a question here about from Susan Stahl about vending machines. Are they included in public accommodation?
Sure. So if it's if the vending machine is in a place that's open to the public, it's in a mall or it's part of somebody's shop, and that's where members of the public are coming in, and the vending machine in some way, shape. We had a division initiated investigation actually with a number of kiosks that recently settled to make them accessible to people with visual impairments. I think Coinstar, and I can't remember off the top of my head who the other one was, but it was a machine that was out and was providing public information. Oh, it was a Reds. I forget. It was the entity that you could get movies from. So it's kind of dated now because everything streams online. But in any event, the answer is yes. A vending machine would be covered if it's in a place that's open to the public, if it needs to be made accessible.
Okay, exam room tables. So if you're going to a medical office and you're a wheelchair user, height adjustable exam room tables, is that something that you would handle?
Yeah, really good question. And this is a big area. We've been working I sit on a group of different entities that are trying to work on access to healthcare issues. So if anybody ever wants to follow up with me on that, I'm happy to get you involved with this group. But yes, healthcare providers are covered as places of public accommodation. So somebody who uses a wheelchair, needs some type of a Hoyer lift or some type of, piece of equipment to be able to get, whether or not the it's one of these lowering examination tables that they can get on it, and the medical care provider refuses to provide that, they've run afoul of the state human rights law requirements to ensure accessibility of services. So, yep, that would be covered as well.
Do tenants have to pay a pet fee or extra monthly fee to landlords for their pets when they have an emotional support animal or service animal?
Right, so that's prohibited under the housing provisions. We didn't talk about housing today, but under both the Federal Fair Housing Act and the state human rights law, landlords are allowed to have fees for pets, but emotional support animals or service animals are not pets. So having a fee for a pet is okay, but asking the landlord to waive that fee because you have a service animal, not a pet, if the landlord refuses to do that, they have run afoul of the housing provisions in both the state human rights law and the Federal Fair Housing Act.
Okay, great. We have a question from Susan Stahl. What about hotels and service dogs? Does it have to be a hotel that allows dogs in the hotel rules?
Sure. So hotels are places of public accommodation. And again, if it's a service dog or a service animal is the phrasing in the statute, so either a dog or a miniature horse. If the hotels cannot refuse to allow service animals, into the hotel, whether it's the room or the lobby or what have you. Now, if it's an emotional support animal, remember, those are not covered under either the ADA or the state human rights law. But if it's a service animal, which means dog or miniature horse, can't be a service cat or a service monkey or service something, or something other than a dog or miniature horse, the owner of that hotel has to allow the service animal onto the premises with the person with a disability.
We had a question here. Are there any resources you're aware of that include estimates or provide examples of barrier removal and public accommodation, such as, what the estimated cost would be of a, one-step entrance removal? And then,
I don't, to answer that question directly. I know there's an outfit called Barrier Free Living. I want to say they're in Long Island. I don't know if they're more residentially inclined than not. And again, I don't know, so I don't want to give bad information. So, when a complaint comes to our agency, I don't think there's a necessity to have some professional resource available to say this is what the cost is, because the burden is on the entity to show, the burden is on the place of public accommodation to show this is not readily achievable. So, they really should be the ones providing information from either an architect or a designer to say, hey, we got this request for the ramp and it's going to cost $10,000, and here are the plans and here's the reason why. So it's not really incumbent on the complainant or the person with a disability when they come to us to say, hey, we hired an architect, or first off, the business owner isn't going to probably allow the architect to come and do a full mock-up. But so I wouldn't be so worried. But I mean, just in the way of resources, generally speaking, I really don't know of any that are dedicated to that. So that would require both of us to do a bit of research to come up with.
So I know Pat Connors had their hand up, so I'm going to allow you to talk and ask your question to John just quickly.
Hi, John. Sorry about that. I've
Okay.
had to multitask and send out an email. My hand was not up, so I will lower it now. Thank you for a great presentation, though.
You're welcome.
Okay. Gemma had her hand up as well, so I'm going to unmute Gemma. If you want to unmute yourself, Gemma, ask your question. I'll take another question here from the Q&A. Would home care agencies providing Medicaid funded personal care services have any Title II applicability? And they're asking because their understanding was that the Supreme Court's Homestead decision was based on the ADA's integration mandate under Title II.
Read the beginning of that question again to me, Alex. I'm sorry.
Would home care agencies providing Medicaid funded personal care services, so they're providing Medicaid service to somebody, have any Title II applicability? I guess this is an ADA.
So we don't enforce Title II, but we do we've adopted a lot of the Title II requirements under our law. So I probably would just need a little bit more in the way of facts. If it was a home health care aide or a home health care company that was refusing to provide service, refusing to accommodate, we'd have to get to the bottom of why they were making that decision, because typically a home health care aide is in the business of making sure somebody, is otherwise living in a way, somebody with a disability or an impairment otherwise has access to, living services. So I guess I need a few more facts to answer that. I would say generally they are covered, as if you are a business that's open to the public and your business is to provide home health care attendance, and part of your operations or practices are to deny services based on disability, you better have a lawful reason for doing it. And if you don't, you are covered as a place of public accommodation under the Human Rights Law. So you're going to be asked about it.
Darlene had a question about food pantry drive-up service.
Mhm.
I guess if that's something that, can be like an accommodation or a modification for somebody.
Yeah, so if it's a food pantry, and their services are open to the public, which food pantries are, and you were asking for a drive up or some type of accommodation to be able to access the food, again, they'd have to be able to show why this would be an undue burden, or, why is it they can't provide this service? If they're just refusing it, I would encourage either, if you've asked and they've refused and you're not getting anywhere, you could file a complaint with our agency for us to investigate it.
So there's a question here about settlement or agreement on public accommodation. How is the follow-up handled? Making sure the staff was trained or the signage installed?
So we have, depending on what the agreement includes, and sometimes there may be in the agreement that they need to report back to DHR on, or show their policies, show sign-in sheets for the next, 6 months or a year or whatever it is, that their staff has been trained on such and such dates, to show and demonstrate back to our agency that they have met their obligation under the agreement, is something we can monitor. Typically, if our division initiated investigations unit brings such a complaint, they have a time frame in there which they will actively monitor whatever the remedy is that was agreed upon.
There's a question here on how people decide whether to file a Division of Human Rights complaint or go to state court.
So, it depends on so if you're outside of the 1 year statute of limitation, you have to go to state court. That's an easy answer. If you're still within the 1 year, I would like to think we're a more user-friendly alternative. If you go to state court, there's filing fees. If you go to state court, you really should have a lawyer. I know people go pro se, and that is a way to do it, but, and lawyers cost money. So, you don't need either of those when you come to our agency. There's no filing fee. If you get a probable cause determination, an attorney will be appointed to your case. Does it take time? Yes, but it would take time also. If you filed a complaint in state court today, I'm sure it would take a significant amount of time to get in front of a judge on it.
Great. So we're just about at time now. As I put in the chat, the slides and a recording will be made available on our website. And, that includes John's contact information. And I know he's generously offered to, answer people's questions, I guess. And
Alex, can I just, one last point, and this could be like a whole other program, but the Division of Human Rights is certified, is a designated agency to certify U visas. And what does that mean? It means that if somebody is the victim of a crime and they are threatened with deportation, they're not a citizen, they're an immigrant, and they are threatened with deportation, or they're threatened to be reported to ICE because they want to file a complaint because they've been discriminated against. We're going to get some language soon up on our website about that, but that's also a resource our agency can provide. So if ILC staff are working with, and there's nothing in our law that says you have to be a US citizen to file a complaint. It just says person, the word is person there. So if you're a person, you're covered regardless of your your immigration status. But we've seen cases here where people, there's a chilling effect, either an employer or more so in employment or housing, but it can be in public accommodations too, where if it's an immigrant with a disability and they file a complaint, or they say, I'm going to file a complaint, then, they're threatened with deportation, that can be something that we can report to the U.S. Department of Immigration Services and try to get them certified for a U visa. We don't provide the U visa, but we can certify them as being eligible for it. And it's a pathway to citizenship for somebody who's really suffered at the hands of some bad actor.
Great. Well, thank you so much for your time, John. I really appreciate it. We got a lot of really good questions. I've also copied those questions, so if you wanted to answer those at some other time, we can put that together for people as a resource. And thank you everyone for joining us.
Thanks, Alex. Thanks, everyone. Good to be with you.
Bye. Thank you to our 2022 webinar series sponsor, Waymo. Waymo is an autonomous driving technology company with a mission to make it safe and easy for people and things to get where they're going. We believe that fully autonomous technology holds the promise to improve road safety and offer new mobility options to millions of people. This is why we're designing Waymo Driver, our autonomous technology to give people a new kind of freedom to go where they want, when they want, while making the frustrations and concerns with driving a thing of the past. Logo fades into view. New York Association on Independent Living.